not working again today?
I think at some point, Jones, because I got a text, I think at some point it shut off, but we were in the middle of it, so I didn't even stop it.
Oh, did that happen today again?
Unless someone sent me a text, I didn't know, but someone sent me a text
Today?
yesterday.
Oh, okay.
Remember when I guessed it? You
Yeah. So it happened again today.
said it was off.
All right, how do we get out of this? There we go. Okay. Folks, are we ready to start back up again? You guys ready? No? Mr. Davis said no.
Oh, I think so, Your Honor. I think someone has to.
Sure, what happened?
So yesterday disclosed to Mr. Day that in this case as a prior conviction for
Who has a prior conviction?
I victim,
Okay.
and probably impeach that victim stating that Mr. Day was to have possession of the judgment acceptance of the day and obtain the judgment acceptance. You have case law for that. It is Barclay State, 68 Southern 3rd, 412. Apologies, Mr. Day, I don't want to put the court, but I will.
Well, what's the issue? Is the issue impeachment of witness or what is?
Yes, Your Honor.
Whether Mr. Day can impeach his witness? This is the state's witness?
The victim.
Whether Mr. Day can impeach the victim?
Yes, Your Honor.
Is Mr. Day saying he can or can't? What are you guys fighting about, so I understand?
Your Honor, I just want to make sure that there is no mention of the prior conviction used for impeachment.
Aren't you allowed to ask someone if they've ever been convicted of a crime?
As long as we have, according to the case law, the proper certification to do so to prove that. My understanding is that Mr. Day is not. And again, Your Honor, it's this.
The issue here is the state's claim is you cannot impeach unless you have an actual prior judgment sentence in hand. In the case of one hand. That is not my understanding of the law.
That's not my understanding either, but I'm intrigued.
To do it, and you know they have it. You don't have to have the actual judgment sentence unless they deny it. If they deny it, then you can't go any further unless you have the judgment sentence and actually show them.
That's what I thought, but I haven't seen this case.
I apologize. I only have a single copy of the case.
That's okay. Sorry, I'm taking this mask off. I got something on it. It's driving me nuts. Okay. Let me see. Well, I'm gonna let Mr. Day read it, and then I'm gonna see if I can pull it up myself too. And I appreciate you bringing that up before we brought the jury back in. What's the site?
Then yeah, the judgment site is 68 Southern 3rd, 412.
Okay. Is it Jones versus State?
Bargaining versus state.
68 Southern 3rd, 1212 comes up as Jones versus State. Why am I finding it?
68 Southern 3rd, 412.
Oh, that's weird.
I can still talk to Mr.
Oh, let's just pull it up again. I didn't like pull up last one. I just pulled up from the site. Sure, that'd be great, just for me to just try and find it. Yeah, because this one says Jones versus State. Thank you. Well, whatever I'm looking at isn't, I'm gonna go to Westlaw. See if we find it that way. All right. Southern 3rd, 412. Just trying to take a look at this.
So, just for the record here, the state disclosed last night, that the alleged victim in this case had to require that. The state takes this end of the day, so the prosecution that wants to impeach a witness. And the court came back and said that the prosecution won't be able to impeach the witness, needs to have the records and documents. Now, when this came up years ago, one of the issues with circuit court, the way you can obtain someone's criminal history is through what's called an NBI check, which is not accessible to the defense lawyer. Only accessible to police officers, prosecutors, judges, probation. It is actually a crime for the defense lawyer to access that computer and obtain that information. We have no way to check our evidence. Of course, time to change the rule of it to Google search. So the Google search is not a record search. There is an obligation on the part of the prosecution to disclose to us if a witness has a record. They do, we get to now they're coming in and asserting that we don't have the judgment system. They're correct, we don't, but they just disclosed it. And they probably didn't tell me where it's at. Where is she getting that? When was it? So I can't judgment conviction. If the state's going to object now, they're untimely disclosure of that information. I accept that. I have to declare a mistrial. They'll need to comply with their discovery obligation to give me that. I might point out to the state, though, just so they know that their alleged victim lied to them. Because I did do a little bit of homework, living around information I find, she had more convictions than she told her.
And
So you might have to
in your honor, just for the record, this is a perfect and not always a criminal history. You have to be giving her own focus, felonies, crimes of dishonesty. What the state has seen, what the state has been told by its victim, by its witness, is that it is that single fact. There is no other criminal history that is related to those things should be barred by medical evidence to begin with. As it relates to this case, I did disclose this report yesterday that we have 2019. All of these by not specified a specific county, it is remote. I believe that's remote or remote county. But yes, Your Honor, that is a different state as it relates to impeachable offenses, felonies, crimes of dishonesty. That is the only criminal history that the state is aware of. That is the only criminal history that would be able to be used to impeach the victim in this case. And based on the case law that the state has cited, Mr. Daly would have had the county given cases to make the defense at the time.
I disagree. I'm allowing it.
One other thing again, about you're addressing this issue. I heard from the state that they called the victim and they didn't confirm that she had been charged with conviction. So I see that it's not.
No prior as relates to people offenses.
Crimes of dishonesty is what
And crimes of dishonesty or felonies, yes.
I'm reading right from 90.6107. A party may attack the credibility of any witness, including an accused, by evidence that the witness has been convicted of a crime if the crime is punishable by death or imprisonment in excess of 1 year under the law under which he was convicted, or if the crime involves dishonesty or a false statement purposes of punishment. So tread very carefully on this, please, gentlemen.
She had unlawful use, false name and identity, and person that was convicted in her name, her date of birth.
I do not believe that was it.
Well, the records show.
Why don't you guys take a minute and share the information that you each have, because what I don't want to do is have something that appears to be more prejudicial than probative and end up with a disaster in this case that we're just getting ready to start.
Again, for the record, I can't access the same records that they can. All I can access is public record. And public records like the records marked or the unlawful use of false name and identity. The records, public records, where I can let the courts show that it was adjudicated on that record.
Your Honor, any questions that you discuss?
Of course you may. No, I want everybody to be prepared on this issue so that we or have an understanding before reading the jury back in.
While we're at it,
Yes.
October 16, 2003, she was convicted of the felony charge of criminal mischief in excess of $1,000.
Where's that?
That's Broward County. Same name, same date of birth, same social security number. She had actually three charges. She had a trespass, a burglary, possession of burglary tools, and criminal mischief over $1,000. It looks like a criminal mischief is what she was convicted of. Out of those three charges. For multiple other offenses, she was arrested for those who wanted to somehow the Broward record wrong.
I'm going to give Mr. Robb an opportunity to look at that. I did notice that today.
Here's the issue. The conviction that she had of Broward is not an public record. So you public record, this is the only thing I mean about that is to take hold of it. Although earlier, that's like a mini arrest. Well,
Well, it is argument, but at the same time, I don't want this to turn into a trial where the victim's on trial.
You know? It doesn't come back to so these records are completely contrary. Unless someone using their name or ID, something to them.
I don't know. No, that's okay. As I said, although I don't like to have the jury run unnecessarily, I want to have this issue resolved before we come back in. So take time to look at it, and then we need to resolve how we're going to address it.
October 16, 2003, Broward County, for Social Security number, same address as previous charges, that is trespass.
Yeah, it goes
Yes, over 16, this is one right.
I'm showing this on, yeah. That's really the other one.
Thank you. Yes.
Okay.
No, I did hear with the big one, the big one, it said that, the Broward County position with the false ID is correct. She did it, that had not been disclosed. As it relates to the burglary, she's yesterday, so I think he said that
And that has been verified by you.
Yes, Your Honor, I'm speaking with the, through DCIS, yes, Your Honor, I'm speaking with the victim. I'll also say that as it relates to false ID matter, it wasn't there, does not have a date of sentence. The state again is based on the request that it be included in using that communication for the.
Nope, I'm allowing it. Sounds like everybody knows about the information, been well aware of it. It was disclosed by the state last night late to the defense. And the defense actually had a printout showing information that was different than what the state has. The state and defense have actually conferred with each other and shared information and agreed that there are these two convictions. That agreement has been made on the record. I'm not required certified convictions because everybody knows about them. You've conferred with the witness has admitted them, so the court is allowing it. Now we're ready to bring back the jury. All right, let's bring them back.
Need this for a week.
Thank you, sir.
The time comes to Mr. Robb, have you moved it a little bit because the way your pencil had its position yesterday, I couldn't see anything, but I wasn't going to say anything. Yes, because he had it literally right in front of me. Maybe just a little bit over, like, well, maybe closer to the podium so I can still see. Because yeah, it's kind of right here, it's right in front of me. You can move it up so that it's closer there, so that you can see it, just so, because I can see a few of these people, but I couldn't see the rest. So it wasn't really, it didn't cause any real difficulties. Just if it could be moved a little bit for today, that'd be great. I always just like to keep an eye to make sure, you know, everybody's doing what they're supposed to do.
Round the jury.
Thank you, everyone can all be seated. Ladies and gentlemen of the jury, I truly appreciate your patience. As I said to you at the beginning of this case, there are some times during this case where we may ask to take you out because we have matters we need to discuss outside your presence. That happened for a little bit outside of the hour, but we were able to accomplish a few things. So I apologize for making you wait, but at the same time, as I said to you before, I don't know sometimes when we're going to have those conversations. So I do appreciate your patience in waiting for us to get started this afternoon. We are, however, ready to get started, starting with opening statements. Mr. Rabb, are you ready to proceed? Okay, please proceed. Thank you. You may.
Reviewing Sunday, 2020. Ms. Donna Smith, a mother of four, was home making breakfast for her own mother, who just recently suffered a stroke. Ms. Smith was home with her mother, 3 of her 4 children, her sister Daniel, and her sister's daughter. As Ms. Smith was finishing making breakfast in the early afternoon, about to march on their service, the defendant in this case, Mr. Nicola, Ms. Smith's stepfather, came home. For whatever reason, as he heard the refrigerator open and Ms. Smith was reaching to grab some butter, it enraged the defendant. Today, they were hearing testimony from Ms. Smith that at that point, the defendant would yell at her, "Don't go right here!" Words that exploded. Ms. Smith's sister would hear echoing throughout the halls of the house. He then indicates this, striking Ms. Smith on the left side of the neck, bleeding lines. This was in the presence of Ms. Smith's 6-year-old son, who wanted to protect his mom, started to rush towards the defendant, but Ms. Smith prevented him from doing that. And rather than taking action herself, told her son to go and get her phone and shut all the recordings. Finally, today, you'll hear testimony from Corporal Andrew Moore, Northern County Sheriff's Office, former domestic violence unit detective, former homicide detective, will testify that upon arriving at the home was immediately met by the defendant, who throughout his investigation gave an inconsistent statements as to what happened that day. And you'll also hear Corporal state that the physical evidence based on his training experience on Ms. neck corresponded to what he believed the recent physical. Now, at the end of hearing all testimony today, and at the end of the statement presenting evidence to you, correspond to that testimony. Corroborate that testimony. State believes that it proved beyond a reasonable doubt that the defendant in this case, Mr. Nicola, committed the crime of battery against Ms. Smith when he intentionally touched or struck Ms. Smith against her will. Thank you.
Mr. Chair.
Well, we're just that. So in every case, the fact, what you're going to find is his wife in a house here. When he married his wife, she had her children, one of them was about a 6-year baby married, and that was Dawn Smith, the young lady quit. My client raised that child and most of her young life, but she got married teenager, about 15 years old. She died. From 15 to 37, she was about 27. She became diagnosed. She had a couple children. She was pregnant and multiple incidents earlier. On the time she got close to the age of 15, there was obviously a condition with my client. Didn't want to follow the rules. And when she came back with her 2 children, pregnant with another child, she had nowhere to go. Then work. 37. Coming back to the house to live within her mind instead of family. During the period of time they lived there, there was a lot of fun. She would come very angry. She would cuss at him. She was on fire. And what they would do, she simply took over the house and ran. Still unemployed. Still not seeking a job, living my client and his wife. Now, my client is a gentleman, he has a bigger issue, but one of them he has full religious purposes. And there are 2 refrigerators in the house, and he asked her if she could please keep food away and pour it up in the refrigerator. It's not mine or the they had but as a daughter, it was you can't come in with you. You're not my father, you're not my nephew. No, I had to speak about that on the day since it happened. Not only did they get to the point where she got back to his face, into his way from screaming and doesn't know, she can't know what to do. She can go in after every time she wants to, even though we have several years to keep her stuff in. Wasn't only allowed to control it. Now, you're going to hear from my client that specific facts are additionally, and my client has reasons to be afraid of it. You're going to get the her testimony. She has suffered convictions prior to design. So the evidence going to show when this is all done, and not only was she defined, but the story she told what wasn't true. When she started screaming and getting in his face and telling him, you can't tell me what to do, I'll do what I want to do, he pushes her back. He didn't punch her. He pushed her back because she was right in his face, and that is because of the trigger. And the other thing shows when you're older, that he had to be. And the second he touched it, what did she say? I got you now. And she told him this. And that day she won. Now, not only did she plan this, she knew how to plan, and we're going to get into this specific evidence about that. She knew how to keep the music system. Really, confidently, when you heard all the evidence, and listen to all the evidence, it would be pretty clear in this case that not only was my client not to be arrested, an 85-year-old man, not to be arrested, it was the 37-year-old stepdaughter who stayed in the house who was going to assault him. All he did was push away. Now, I can't believe no. Okay. Sorry,
That's okay.
That's
That's right. I forgot too. That's an awful lot of life, Mr. Day. Well, you're doing a good job. We appreciate it. Thank you. Make sure you get every spot done. Thank you. We got to make sure that we remind ourselves too that we got to get those the witness box right down between witnesses. Folks, this is all new stuff to us. I mean, it's a lot to remember. We're trying. All right, Mr. Rab, you ready to call your first witness? All right, thank you. Is she one of those ladies? Yes. Oh, okay. Thank you. All right, Mr. Rab, may I inquire? Thank you.
And I know that he was the self-smith, so I'm just like, I'll say that. And where do you currently live? And how long have you lived here? And you live alone? You live alone?
Sister, I work with,
And you're currently employed?
No, in school.
And where are you in school?
Sunday Academy.
And where are you studying?
Autopilot.
And so, you know, the defendant is driving college.
Yeah.
And how do you know that? And how long has he been in college?
1995.
And was the defendant also living with you at the University City Club on Sunday, May 3rd, 2020?
Yes.
And what were you doing during the late morning early afternoon that day? And why were you preparing your mother breakfast?
She suffered a stroke in people
And what were you making for breakfast that day?
on the details.
On the coast?
Yes.
Can you just speak a little bit louder?
Yes.
All right, thank you. Was the defendant home that morning?
No, not anymore.
Did you come home while you were making breakfast for your mother?
Yes.
And what happened once you came home?
He began to get belligerent and irate about being in the refrigerator.
And what were you going into the refrigerator for?
Specifically, I had a farm mother, so.
So, had nothing to do with you getting food yourself out of the refrigerator?
No, sir.
Having anything to do with you putting food in the refrigerator?
No, sir.
What happened after you saw you going into the refrigerator?
He started to argue with me about being in the refrigerator, telling me that he don't want any of us in the refrigerator. And he came over and started the refrigerator behind me.
And then anything happened after that?
Yes.
What happened after that?
He squared up and threw a punch and then
When you say it's square up, what do you mean that square up?
he took it over.
Did I ask what happened?
The only one that saw was my son, who was 6 at the time.
How did your son respond?
Objection denied. Oh, here's the-
Well, you're not going to do it.
Is it going to call for an answer or something that you told her?
For hearsay.
If you responded with an answer, that would be hearsay. So it's,
Your Honor, I think.
come on, Charlie. All right, objection is overruled. Thank you.
Thank you, Smith. And my question was, what did his timing response? Okay.
He was upset. He didn't want to be about it.
Objection. Yeah. Not what we just talked about.
No, that objection is overruled. Continue, Mr. Webb. Thank you.
You said that he was upset. How did he act upset?
No, that's been sustained. No, we're not going down that road.
He began.
Again, sustained.
Expression can be hearsay.
I agree, sustained.
Your Honor, you-
No, sustained. Move on, Mr. Webb.
What happened after that?
My son charged towards the park, and I stopped him, and I told him both that my cell phone was
And you publicly said that
yes,
you were aware of how that call was recorded at all?
yes,
And Your Honor, now we're going to want this to go on. I have disclosed to you today.
Yes.
And first witness, Your Honor.
Yes.
This is I am showing you that you bring up the states of the one you recognize exists.
yes.
And that exists.
That I drew a 911 call.
And I recognize that this is a copy of the 911 call. I recognize that. And is this the clear and accurate representation of all that did?
Yes.
And the current taking this case against you to one evidence, we request that we be able to publish your hearing.
Any objections, Charlie?
I understand it's been back, the redaction, no objection.
Okay. Are we going to play it now or are we going to play it later?
I would like to publish your hearing.
Okay, granted.
Thank you.
Thank you.
If I may play your hearing.
Yes, sir.
Your Honor, and I'm on my computer, so it is where it is.
Sure. Okay, I can try and play it on this computer, but it doesn't look like it has. But this is, it's on a disc, right? And I also have a disc player on the courts on the bench computer, but I don't think I've ever used it, so. Those are the only two that I can see. This one doesn't. Okay. All right, that's fine. I'd be happy while you're questioning to see if it'll play, it'll pop up in the court's computer to try and play it since it's admitted if you want me to. Sure. I have the volume off on the computer too, so. Thank you. Thanks, Joe. All right, please continue.
Now, Mrs. Lennon, did you ever do it with the promotion?
No.
Are you aware whether or not they were, or did law enforcement respond? They did. Speak with them?
Yeah.
Did law enforcement investigate, or were there any for this incident?
Yeah.
And did law enforcement investigate this?
Yeah.
Did they make a difference about it?
Yes.
Your Honor, you're now holding what has been remarked as stated to the Q and 3.
No objection without the credit of the disability.
Okay, thank you. There's no objection to the visibility of these two documents.
No.
Have they been previously marked?
They have been previously marked, Your Honor, as stated to the Q and 3.
Okay, based on no objection, those will be admitted. Thank you. Yes, sir.
And again, just for our jurors, now clearly what has been marked as stated to the Q and 3. Are these pictures accurate representations of the workers?
Yes.
Thank you. And now, specific question to publish these pictures.
Any objection, Mr. Day?
No objection.
All right, it's granted. I may be able to play this audio tape if the parties would like me to attempt to at this point. Whoops, wait a minute, let me get back to the start, if I can play it. Would that be acceptable to everyone to have the court clearing on the call, because it looks like I have the ability? All right. So I'm hoping that you all can hear this because it's being played from my computer, but I'm gonna try.
Your Honor, I just request a waiver bill.
Oh, wait until we're done? Okay. All right. All right, I'm trying to get all the way back to the beginning here in this closet. Okay, we're ready? All right, let's see if we can do this.
Yes, the address is 2020. 68 Island Northeast. My name is Donna Newman. Can you tell the number you're calling from? The phone number is 954 646 Can you leave police fire on the phone? Can you tell me Dr. Williams? My stepfather just took a cooking call. Punching in my neck. Okay. What you're right now. Does he have any other weapons? I don't know. What's his name? His name is Edmund Todd. What's the last name? Todd with the T-O-R-S. What's his date of birth? His date of birth is 7/5/4. Okay, you can just separate, right? He's in the living room right now. Okay, can you just wait for a minute until we have somebody there?
Right. Yes, sir. I'm going to hand the CD to the clerk.
You recognize the person that you previously identified and try to farm
Yes.
and you can only identify yourself. You have any identified individual that finds you that day. You have a financial squad that day. You know the question behind.
Okay. Thank you.
Exhibits, please.
Yes, sir. Remember, we just write down the podium page here.
Oh, yes.
Yeah, that's right, Mr. Rabbit, it's your turn.
One would be sufficient for me. Thank you.
Thank you. All right, Mr. Day, please proceed.
Maybe you started yet? What is it for? And that's reason I asked you that is you have a problem with that. Okay, so that's what you want to do. When did you browse around and move into your mother and sister?
I do not believe that I
So from August of 2019, visiting your college and school in February, for the employee?
No,
I mean, children.
I haven't worked before.
You came that 3 children you were pregnant, and you first came to talk to your mom, right?
I have 2 children, I have a pregnant woman.
Okay, so I didn't know that. And then you carry on to the. Yeah, okay. So now, since you did live in there and you were in your house, it would be a fair statement to say with time, you could just part of that.
What's it?
Would you agree with that?
Yes.
You guys really got along with you. Okay, and when you were back living with them, would the two of you argue on that?
Yes.
Did you ever raise voices in it?
Yes.
Did you ever cuss at it? Never cuss. And so now, let's talk a little bit about, first of all, have you ever been convicted of a crime of dishonest?
Yes.
And what was that?
The first time was I had my cousin's identification.
This is about impeachment, this is simply about a crime, she has been convicted of a crime of dishonesty.
He actually didn't ask her what she did. She volunteered that on her own, so. However, Mr. Day, you want to ask the question differently. Sometimes witnesses volunteer things that they're not supposed to.
Yes, okay. You disclosed not everything to the prosecutor.
Yes.
And did they ask you what your medical condition was?
Yes.
And you told them about that,
Yes.
right? Now, that wasn't exactly true when they were when you told them yesterday.
About
Your prior medical condition is
I was supposed to I was convicted for
Your Honor, yes.
Sustained.
So then they're communicating today, we revealed to them another offense, which is admitted at the moment in time.
Yes.
You tell them right away.
Did not have someone, no.
Matter of fact, you tell them about it, so they went out and called and asked you about it.
Your Honor, this is my line question, this is called.
No, overruled on that issue.
That's correct, all right, that's that.
Yes.
All right, and then they asked you about it, you remembered it.
Yes.
So you didn't forget the question, the crime is fine.
Yes.
Okay. Now, when you called the police and the police responded, you remember the occasion where the police asked you to fill out a statement about what happened?
Yes.
And they asked you to write in there details you can about everything that happened,
Yes.
from the beginning to the end.
Yes.
And did you think you did it?
Yes.
You wrote out everything that happened,
Yes.
right?
Yes.
And your understanding the police was that you're supposed to not leave it out, right?
Yes.
It's important to know every step of what happened, okay?
It's okay, you put down in the remember that?
Oh, okay. I'm not sure you got it, that's the council, they said that, Scotty.
Browns? Why would there be a lack of predicate? Overruled. I don't know if it's attempting to impeach or he hasn't asked her any questions yet. So I'll let her to look at her statement. You may.
Just ask you, what take a look at this, you say. So when you guys just one statement to the police, you never wrote the next one statement about my son Charlie working fire. Not that far ahead. Okay. Now, let me show you what's marked as statement.
What is, oh, the pictures? Any objections to that? Okay, you may have that.
Let me just show you statements of the two, real quick, and ask you to take a look at that. Now, when you said you are watching, we said you call this this? Yes? And he struck you.
Yes.
Where did he strike you? Okay, could you point out where? Let the record like this is pointing to the left side or the middle of the head? That right? Reason I asked you that question, which you agree, is exhibit stating exhibit 2, underneath your chin, up high is red marks, red. You ready? Okay, that's why I'm trying to be clear. You would agree there's a red mark. Okay. And as a matter of fact, states exhibit 3. I'm sorry. I published you agree.
Yes.
That is it, just as well. Now, I think we read it. Now, taking a look at statement exhibit 3, which is the same general letter, different angle, agree? And on that photograph, would you agree there's a red mark on the lower portion of your neck? And then would you agree there's a red mark on the upper portion of the neck? With a white strip between those two with no red marks. Would you agree?
Yes.
Okay. The publicist agree.
Okay.
They're in the refrigerator, located in the kitchen, there's actually two refrigerators, right?
Yes.
And one of those refrigerators, Mrs. Clark previously asked you to keep yours.
Overruled.
Right, right. And then the refrigerator is not loaded,
Yes.
right?
Yes.
There was some dispute about that from you. To be fair, right?
Yes.
You wouldn't dispute.
No.
The times that you thought you would, you did it.
Yes.
You would tell them that.
Yes.
Never tried.
No.
But sometimes you get loud.
Yes.
You be angry, right?
Yes.
The anger about a lot of things, right? And you would express your verbally.
Okay.
Okay. You don't dispute that happen a lot.
That is correct.
All right, all right. And the only occasion then that the first meeting that he offered to get out and repeat things that you didn't want to do, right?
That is not true.
Not here.
No.
So you can keep it in the other than the.
So going to the information, when I first moved there, I already designated the white refrigerator as the garage my first trips.
How in the world did you designate mom and dad ever used to keep yours? That seems a little funny.
Overruled.
It wasn't a verbal agreement.
You just said you do.
I was doing it.
Yeah, yeah. Who said, hey, this is mine.
No,
No.
because I stored it in my bedroom because I have space. I'm not, I have to put groceries.
Well, you know, you didn't eat for it, correct?
Yes.
You know, you didn't want meeting stuff in your refrigerator. You knew that.
No.
You didn't know that?
No.
Really?
That was not.
Okay. So once you said that you got to stuff in there. The day of the vacation, I people are actually, and so the next hours is stuff in there, such that refrigerator is part of your.
It was not discussed, no, it was stated and I very basic. But he did not say, okay, from here on out, this is what's going to happen. No, he came at me very appropriately, shot at me. It was very us in the house that we were not.
Okay. So I have again now. There was, he said to you, don't use this.
Yes,
Right?
yes,
Okay. The only case are that you're going to use the refrigerator to find people. Right?
no,
All right.
no.
So let me try that this way. You went to the refrigerator and you asked him not to use the refrigerator. That, and then he confirmed you about that, correct? And then at that point, you remember saying, man, you will do whatever you want to do. It's not his pocket. About what's in it? Was that one of the times you angry, you know that?
Yes,
Okay. So again, when he was pushing you out to the you became angry, right? You expressed yourself to him verbally,
yes.
right? And you were very close to each other when you expressed yourself, weren't you?
Not at that time.
Right? So let's back up, because maybe I didn't understand your story. You said that you had refrigerator response and hit you. Remember saying that? You then said you punched the refrigerator. Okay, so to punch you, I'm going to assume you were in an arm's length of it. That's a fair assumption. Punch you, yeah.
Yes,
Right? So when the door slammed, you're standing in the door. Yes.
yes,
He's within an arm's length of you. Yes.
yes.
You're angry, yelling back at him within an arm's length. Okay, then
Initially, when he was confronting me, it was not within arms.
understand. I'm getting to the point where you said it's tough. Exactly.
Yeah.
You were in an arm's length, And then you're going to find out and that's when you say you punish with opposed to this, right? Okay.
Mr. Rath, redirect?
Yes, sir.
Sure, of course.
This is it. Yeah, next today, making primary, animal as it relates to.
Objection on questions, statement.
Stay. That statement's stricken from the record.
Show us where on your neck that the financial occurred. So.
All right, sorry. We have to do this to that again, all in city.
Yes.
Where the records that they get are, she's pointing to the lower part of her neck. I'm going to check the lower part of the neck, left side. Also, as records that they get, lower part of the neck.
And Ms. Smith, the day of this existed, you said you were going to be you going in for yourself?
No, sir.
Were you going in?
Yes. Stay.
Your mother allowed food in that refrigerator?
Yes.
No further questions, Your Honor.
Okay, thank you. Is this witness excused?
No, Your Honor, it's still.
Okay, thank you. Please sit down. We need to write down the witness box. Oh, you did? Thank you. And Mr. Rad, did you get the podium?
I'm gonna go back up.
Oh, okay. For Mr. Today. Whoever leaves takes the floor. How's that? I'm taking this opportunity to stand. Ladies and gentlemen, I think everyone's not going to sit all day. Anybody who feels in a little break situation, you want to stand, please feel free. That was one of the things they didn't prepare me for as a judge with all the sitting, so I stand once in a while. We have somebody coming from outside to come in.
Yeah. I got some.
But no, we're waiting for someone to sanitize the podium. That's what we're doing. We need the lady who comes in twice. If we don't have her in like 1 minute, we need a volunteer. Joe's got it. Thank you. Thanks, Joe. See, you give it one mic, guys. All right, Mr. Brad, please call your next witness.
Ms. Stark, you are very soft-spoken, so if you wouldn't mind when we're being asked questions, you, yeah, just speak up a little bit, because everything, I explained this to the jury, but I never get a chance to explain it to the witnesses. We don't have court reporters anymore, so everything's recorded.
So when we have
When we
somebody
have somebody
who's
who's
kind of
soft-spoken, sometimes they can't hear you.
Yes, I know, I get that a lot.
But
Now that I'm telling you that, I can definitely hear you, so thank you.
All right. Okay, Mr. Evans, proceed.
Ms. Clark, please state your full name for the record. And can you please spell your last name, please? And Ms. Clark, where do you live? And is that in order? You live alone? You live. And who else? In the house. So, Ms. Clark, are you currently employed? And where are you in school? And, you know, the defendant in this case is directly. And how do you know her? You say they father to your father. And we can identify that person that by pointing and identifying that person with the things that identify as his father. Can you please point and identify the article of clothing of that person wearing? Can you point at you can say wearing. Right. Ms. Clark was the defendant due on Sunday, May 3rd, 2020. And during the late morning, early hours of that day, or you can listen to music at all. Okay. Was the defendant? He was not. Did he come home at some point during that day? And what was that? Do you remember? In the morning, early morning. And what happened when the defendant came home that day? Okay. And did you hear anything after that? Okay. 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 Did you come out of your room at that time? Okay. And see your sister? Okay. And so you have to comment. Yes. And at that point, did you see any markings on your arm? Where? On the neck. And your arm, again, please get to this.
Yes. Yes.
And you identify roughly where that record are, or where those records were. Yeah. Circle it with your finger and see if you can. Okay. Okay. And what about this office? Okay. Now, Mrs. Clark, have you seen your sister earlier that night? No. You hadn't seen her earlier that night? When was the last time you saw your sister before we did that? Was? That day? Okay, so not 10:11 Friday night, 10:11 that night. Okay. And you saw her then, did you have your remarks on that? Before the incident? Okay, so when you saw her in the earlier and more. Or the CD right now it's on. Okay. No further questions, all right.
Just curious. On this point, you said you lived with your mom and your sister, right? And your kids, right? I mean, some years. All of that, right? Okay, and you weren't working either during high school? Okay, and now you're in college. Nothing for
All right, thank you. Any other questions for her? Is this when witness is used? Okay, ma'am, you'll need to wait outside in case you're recalled. Okay, thank you. Thanks, Jeff. Mr. Rapp, next witness, please.
City Falls Corporal Andrew Henry.
I think once we call this witness, we'll take a break. That makes sense? Okay, that'll allow our video, Owen to have a little bit of time. Thank you.
Do you solemnly swear or affirm or testimony
Yes.
Please state your full name for the record
Andrew,
and have a spell your last
HGNCHES,
name. And how are you currently employed?
I'm pretty sure.
And are you assigned to the community?
There's a relationship bureau.
And go to school? And how long have you been assigned to that particular position?
Since 7 years.
And what was your prior assignment?
I was a detective in West Palm Beach. 2018.
Do you have any other history or experience investigating very violent crimes?
Yeah, started there, as a detective, violent crime unit. Was a homicide detective for 20 years. 2013, Special Crime Bureau exploitation and human trafficking.
And well, I'd like to turn your attention to the early operating behavior of 2021 feedback.
It was
On that day, you dispatched the 2560 Academy.
very,
And what was that in reference to?
medical surgery.
And on arriving on scene, you made contact with the practice business service water report. The scene is that please point to that by my and you made contact with the support. And what is it? What happened that you support public?
English research the victim, and he was upset because his father was in his refrigerator, getting food that he didn't like to eat, he didn't like eating in the refrigerator.
And you said this is one of also that you need to disconnect.
Sorry,
And was that the story throughout that entire day?
initially, and as we probably would have been later.
Objection, Your Honor. Spoken by
approach. Oh, we need to stay here.
Corporal, as I asked, was that a consistent statement that I made that you were within?
You later stating that you didn't try to push it.
Now, did you send signs of delivery on the victim? And what signs were those?
She had very much on the left side.
And speak of it, and see any indication of any rail to the defendant. And based on your training experience of both testimony that you collected that day and physical evidence at the scene, what was your conclusion?
Stay.
What did your evidence need?
Sustained. You do phrase for questions around.
Based on your training experience in violent crimes,
Sustained. Mr. Rob, you need to rephrase.
was the physical evidence that we saw on the victim in this case consistent with testimony that they what about that?
Well, they got on the push it, and that's more than the more struck.
Mr. Deck?
Sure.
What's that? Yes. Yes.
So, sir, I want to ask you a couple of questions here. So, the weapon says that I'm struggling to close it, correct? So, how is struggling to close it on the left side of the weapon? And to the point that you saw red with this one, did you say that red? Okay. Okay. And when a strike is made to someone, whatever the size of this is, a lot of times compares to the size of the injury. And sometimes when you strike someone with a long object, like let's say a long wooden stick, something that is longer than a fist, you'll need a larger print, larger. Not necessarily increase print, it's not a lot of pressure. Okay, nothing for right now.
Mr. Rob, any question?
Okay.
Okay. Is this witness accused? Accused.
All right,
So sir, we're going to have to ask you to stay outside the courtroom in case you're recalled. Thank you, sir. All right, everybody, so at this time, we're going to take about a 15-minute break. Is that sufficient for everybody? I'll come back at about, well, let's say we'll come back at 20 till. Okay?
Okay.
All right, thank you, ladies and gentlemen. All right, everyone can all be seated? Yes.
No, I don't need you. I just wanted to make sure that we're making you want to discuss this before I took off for a few minutes. All right. YouTube is still on because I still have to do that too. Actually, okay, it's on. I don't know, it keeps going down, but I'm going to turn off my video and mute this until we're back on. All right.
All right, what is it, No.
No, they are, but they're. If we have to do this, somebody who knows, as soon as I want to see it's my boss. Nothing like it done. It's their only job. We're only doing, future jobs. It's not that hard.
Yeah, you don't have to.
Shooting. So,
Have to do it to make it go fast.
no, I appreciate it, because, we're getting a little late today, and they have, I think it's one, she didn't even know, like, come on. So, how are you doing, Natalia? You good? I'm good.
You're just gonna come down, right, Joe?
Yeah, I'll just come down in like 15 minutes.
Okay.
Okay? All right.
Natalia, you all right?
I'm good.
You gonna go use the
I'm
restroom?
gonna stay. I have evidence.
You sure?
Yeah.
Okay. All right.
There's no water back there, those are in the jury room. I'm sure the state attorney's office has water. Well, you saw these are tiny little bottles. You don't get a full 8 ounce bottle of water. Now I know I need to watch my bottle clear because it's clear.
Hey, Joe, excellent job cleaning up.
Hey, listen, I'm getting recognized. I might even get a certificate.
You might get it sometime we did now. Yeah. All right, we'll put you in for it. You forget now, this is the second occasion I'm going to trial with you. First, you and Aaron actually back down to the ready, but now you can, yes, I mean.
Good.
You actually consistently play.
The battlefield is expanding.
Yeah. And the temperature dropped to 5 degrees.
This is- I think these young attorneys should be at the table and get the full effect of it. James. I think these young attorneys should feel the pressure up here. They should be up here feeling the pressure.
Yeah, like a tag team wrestling match.
Get these young attorneys at the table.
Sure. You don't have enough of a lot. James can't afford to live anymore. He'd be in court every day himself. He's the only guy that got a promotion in backwards. He's now doing good cover this year, going trials.
James, you'll be at the table like old time.
You'll be doing misdemeanor range soon again.
Nothing wrong with that.
Hey, I'm wiping down tables, it's all good.
I'm doing a damn good job.
I only use one wipe.
Who likes with one? I hope you're not using the same one over and over.
Well,
Beggars can't be choosy, right? Got a wife. Good enough to talk to you. And he took his nails. He took his nails.
All rise for the second session.
Thank you, everybody. You guys can be seated. Are we ready to bring the jury back?
Ready?
Yes, ma'am.
All right.
run on the jury?
You're fine. You can have a seat. Everyone else, please be seated. Please be seated. Okay. Seat belongs with us.
Your Honor, sit rest.
Okay, thank you. Mr. Day?
Thank you. He's going to give you one of those seat masks there. Mr. Clark, I noticed you're a little soft-spoken too. If you wouldn't mind when you're being asked questions, if you could speak up a little bit because we're trying to get everything recorded here. I noticed you're a little soft-spoken. Can you hear me?
Just a little bit louder.
So what I said to you, sir, if you can hear me, is, okay, good. Is that you seem to be just a little bit soft-spoken when you took the oath. You're a little bit quiet. So if you wouldn't mind when you're asked a question, if you could just speak up because I'm recording everything. So, and also, Mr. Day, if he's having a little bit of trouble hearing, you're more than welcome to move forward because this courtroom, especially with these masks now, it's hard to hear. Okay, thank you. All right, Mr. Day, you may proceed.
Move up just a little bit, just more closer to that mic if you could, all right? Would you state your full name for the record? Spell your last name, please. C-L-A-R-S-E. And Mr. Clark, where do you reside? Live? How long have you lived there, sir?
Approximately 16 years.
Are you married?
Yes, sir.
Do you have any children?
Yes, sir.
And how many children do you have?
5 sons and 2 brothers.
And are you retired, sir?
Yes, sir.
What kind of work did you used to do?
Seasonal mechanic as a welder.
Just Mr. Clark, a little bit more, okay? You come up in your chair, you come up and go up. Are we good? All right. You just try to get around and get a lot out, okay?
Yes, sir.
So what did you used to do, sir?
I was a seasonal mechanic as a welder.
Okay. And then you and your wife resided in Naples for 16 years, sir?
Yes, sir.
Now, did you have a stepdaughter?
Yes, sir.
And what is her name, sir?
Yes,
Is that the young lady who came here and testified earlier?
Yes, sir.
And now, how was to be married with my wife? All right.
6 years.
I'm sorry, answer.
About 6 years back in
About 6 years old?
Yes, sir.
Okay. And did she live with you as she was growing up?
Yes, sir.
And with your son and another wife?
Yes, sir.
Now, there comes an occasion about 15, she left home.
Yes, sir.
Now, when she left home, were the two of you getting along? When she left home, were the two of you getting along?
She never did.
No, when she left, right, she lived your house.
She just going back.
Okay.
Yes, she makes.
What's the objection?
I
I thought he asked her why she left and he said she just left.
As an answer, Your Honor, as a second, ask you.
I'll be there.
Okay, thank you. Okay, thank you. Sustained.
Your daughter left at about 15, but were the two of you having conflicts? Okay. Well, was she following your rules?
She told me I'm not your dad, I'm not listening to you.
Okay. Did she leave home then?
Yes, sir.
All right. Did there come an occasion years later when she was about 37 and she came back to the house?
Yes, sir.
Why did she come back to the house?
Her mother came over, her father.
That's hearsay. Sustain.
So remember, don't tell me what someone said, right? Okay.
Judge, trying to do the actual question, so why the victim came back to the next time.
Overruled.
So why did she come back home, sir?
She was behind the street.
Okay. And then when she came back,
Overruled.
she came back to your house, did she come back to your home?
No, sir.
What did she have?
Two children and she was pregnant.
All right. And when she came back to your house, about when was that? What month, year was that? That's remember. All right. When she came back to live in the house, did you and her live in the house? Did you and her live alone?
No, sir.
All right. Well, was there conflict between the two of you?
Yes, sir.
And what was her demeanor towards you?
She was extremely disrespectful.
In what ways?
When I see her, she's telling me very personal. And this is my home.
Objection, Your Honor.
What's the objection?
So was she disrespectful to you?
Yes, sir.
Was she disrespectful to your wife? Okay. And then on how many occasions did it get worse, the one that she stated? Did the relationship between the two of you get worse the longer she stayed?
No,
All right. And there were some rules that you set her to live by in your house.
no, like, yes, sir. You get that one, like, you know, this one, it's not like before.
Would she follow your rules or would she just do what she wanted?
She didn't tell you, like, if you were things, if you were like,
Okay.
like, she put it on the phone, my face. Every time I tell her, you won't call. She said, okay, call for these 2 times.
All right. So when she was confrontational with you, would she cuss at you?
Oh, for sure, yes, yes, sir.
Now, did you also know and have knowledge about her, the person getting physically back at the people?
Yes, yes, sir.
Stay.
Yes, sir.
Yes, you may.
Okay.
Yep, let's do that. Give us a minute, please. Joe, this is gonna take like a minute. If they don't want to take them all the way to the jury room, just hold them. Because this isn't gonna take long. All right, gentlemen, Nicola, can you be seated? Okay.
So the issue here is that the defendant in this case has specific knowledge of instances of violence and misconduct by the alleged victim in this case. And part of the defense in this case is not self-defense. And in a self-defense case under the Rule of Criminal Procedure 405(3), information regarding character, and in particular specific instances of misconduct, can be testified by the accused. In the case of Supreme Court case from 2012, it is State versus Smith, found in 573 2nd 306.
Okay, tell me. Hold on, I want to hear a proffer of what he's going to say. Is he going to say that he's actually seen her hit other individuals in his presence, or is he going to say that he's heard that she's hit other individuals? I mean, I'm trying to distinguish what exactly it is that he is going to say.
Well, both. Your Honor, I would certainly object to any hearsay that he's aware of as it relates to prior acts and not within the impeachment issue as it relates to prior acts or, I guess, this is a matter of reputation.
How would we get the hearsay on Mr. Day that he's heard from other people that she's been physically violent with him? I can understand that if he's seen with his own eyes her being physically violent in his presence, that has some bearing as to how he would be in reasonable fear for his safety. But a hearsay about other people and other individuals seems like it would be unduly prejudicial versus probative.
So that's what I'm thinking.
Yeah, what the Supreme Court has said today, if the defendant has knowledge, and that's under heading 1617, the defendant's testimony that he knew about specific acts of violence committed by that victim is relevant to show that certain here the reasonableness of the defendant's apprehension to support a self-defense claim. And they skip down. Testimony that other people knew of specific acts of violence committed by the victim is not relevant because it should provide the defendant's state of mind, which shows only the victim has to be violent. So what happens in this case is there were two specific lines of questions. First, the defendant got on the stand and said he knew about the alleged victim's propensity for violence. He had heard about specific acts of violence. He knew about something and he had heard about something. Then they called in that case actually witnesses to testify regarding their observation. And the court addressed both of them. What I'm going to witnesses today is only to testify to the defendant. But information that the defendant has available, even things that he has heard regarding violent nature of the alleged victim in this case, it goes to show the reasonableness of his apprehension for the defendant. And in Smith's case, as a matter of fact, that's exactly what the defendant testified to. In particular,
Yes, tell me where I can find the information on that. Thank you.
So, page 659,
Well, tell me whether it's on page 129. Thank you.
what happens there is, the facts, the court is claim of self-defense. Smith testified, when he shot Castro, he knew that Castro had an extensive history of violent crime. That history was a repeated mafia figure. The Castro had attacked him previously, and the Castro usually carried a gun. Smith said he picked up his own gun and so on and so forth. And, I'm sorry, go ahead. And then it goes on to say that other testimony shows that Castro had a reputation for being violent. That's the first person that we don't have here.
Your Honor, in this case, that's looking at how the defendant in this case, the case that is cited, was aware of that, whether it was first-hand knowledge or hearsay. Your Honor, it is extremely prohibited of the defendant in this case to allow hearsay testimony or reputation that the defendant in this case might have heard, might have been correct, not even knowing where that testimony is coming from. That is extremely prohibited. But he has to understand knowledge. That is one thing. Hearing it, second, third, and does it completely differentiate? This is attempting to carry a mock of the boss to a mock of other people.
I agree with Mr. Day. I think that's what the Supreme Court says, so I will allow it. Bring the jury back in.
Round the jury.
Thank you, everyone. Please be seated. Is overruled. Mr. Day, please proceed.
About when she came back home and wanted to interact with her. Okay? All right, so now, Mr. Clark, were you also aware that the stepdaughter, Ms. Smith, and became violent? Very violent. And you were aware sometimes that she would be that kind of victim, violent with you? Yes, sir. And we also aware that she had instances in other codes where she had instances of violence with other people. Yes, sir. You were aware of all of that, and aware of all of it. And you were aware of that prior to the incident in the refrigerator. Yes, sir. Now, because of those incidents, did you have some weird person apprehension? Yes, sir. All right. Now, the day of the incident that the refrigerator occurred, where you came home, was she at the refrigerator? Yes, sir. And did you have a conversation with her again about what you asked her about the refrigerator? Yes, sir. And how did she respond to you, sir? Okay. But was it your house, sir?
Slightly to do.
Now, let me ask you, hold on a second. How close are you to her when all this is happening?
Close enough.
Okay.
Because
Within an arm's length?
That's it.
All right. And she's trying to, she's angry. Was she angry and yelling?
Yes,
Grounds?
sir.
What's that? Overruled.
Was she cussing at you?
Yes, sir.
And at that point, was she close to you?
Yes, sir.
And now, again, so how did you push her away? What part of your body? You're pointing to your arm?
That's the one that was started on the spirit.
Okay.
No, the right hand.
So you use your left hand, your left arm?
Yes, sir.
Okay, and what part of your left arm made contact with her? And where you're pointing to your elbow there, front, forearm? All right. Where did that touch her at? All right. And after that, what did she say to you? Okay. And did it say? I'm sorry, say one more time.
That's all that I want. I give you a lot of nothing.
That's it. You gotta say one more time. All right, let's hear it.
That's all I want. I give you a lot of nothing.
Yes.
Yes, you may.
You don't have to yell, okay? Just move your mask up very, very bit. Just very, very bit. Just say one thing, not too bad. That's all I want. I give you a lot of nothing. We're not understanding the last part. You have your what? Your house, left, your past. Okay, we got it. All right.
That's right.
Mr. Fuller. Thank you. Mr. Fuller, how long did you say that incident lived with you? When did she came back from their house?
I should say, before the incident.
When did she move it? About 3 months. And from that time, you stated that you both had a conversation regarding the refrigerator, correct?
No, right.
No, not all the time. So, but you did say that you had told Ms. Smith that she was not able to put certain food in a specific refrigerator, correct?
She did not say, I told her not to do it. She did not say,
Okay, so when you came home that day, you saw her going into that refrigerator, same on the kitchen, correct? And that's the one that she was using, correct? Okay, and how far away were you when you first saw her? 10 feet? So 15 feet away, more than an arm's length away, right? And then you approached her, right? So you went up to her and you said, don't go in my foot. Okay. And then after that, you took out a refrigerator door and you saw it. Is that right? So you admitted that
One at a time, everybody. Hold on. Question, answer. Don't talk over each other. First of all, it's very disrespectful, and we're both adults, both of you. You guys can get through this without that. Please continue.
So, Mr. Fuller, you stated that when you first saw Ms. Smith going into the refrigerator, that you were 10, 15 away, right? And then you told her that.
Hold on. Mr. Clark, when the attorney asks you a question, a head nod isn't something that we can take. You have to say yes or no because we're being recorded. I saw you nod your head, but in order for us to have a clear record, I do need to make sure that you answer. That's the only reason I'm stopping you, okay? Thank you. Please proceed, Mr. Ross.
Mr. Clark, you were 10 to 15 feet away. You told her don't go in the fridge because you saw someone going into the fridge. And you had no idea she was going into the fridge?
No.
No. So you didn't know she was putting her food into it, right? You didn't know whether or not she was putting her food into the fridge, which is what you or not. Right? That's right, so she had her fridge. Right. So she wasn't putting food, when you saw her that day, you didn't see her putting food, you just see the still in the refrigerator, right? Okay. So then when you said that you were 10 to 15 feet away, her, don't go into the fridge, then you approach her, correct? Okay. So at that time, you continued arguing with her, right? I think the statement that we had at the beginning when we took the stand was, you have a big murder for a long time, right? So we continued to argue with her, right? But you didn't argue with her at all? Really? That big murder, long time, you didn't argue with her at all? I'm sorry?
I use it properly.
You use it properly, so you never purse yourself. That's what you're saying? You have a purse? You ever use those words?
No, I never purse.
You never purse your life? Never, only once. It's not like saying last year day, right? You never purse more in your life.
Never.
Okay, so, Mr. Clark, you approach this man inside the refrigerator, who's making breakfast for your wife, and you tell her, don't go in the fridge. You know what? Right. And then she's going in there for your wife, right? Not her. Not her, for your wife. Okay. So you said that she's going into the fridge to make breakfast for your wife.
I did not know why she didn't afterwards she mentioned.
Afterwards,
No. No. You mentioned it in your statement. I have to say that. I never heard you comment on that.
You've never heard anything about my wife.
Oh, she was not.
So what did you see her doing when she was going in the fridge? What did you see that she was doing when she was going into the fridge? You didn't know, you just didn't want her in there. Right? You didn't want her in your fridge for any reason, right? And that would include to get something, even for her mom, for your wife. Correct? She wasn't supposed to do that for her. Now, Mr. Clark, you said that you stated before that Miss Smith was a problem child for her, right? Is that what you stated? That she was a problem child, that she got into the issues? Is that what you said before? That you had to discipline?
She's very respectful.
She was disrespectful. Did you try to discipline her when she was a child?
You
You never did try.
Yes.
Did you have rules growing up in your house? When you was growing up? You gave away the rules of it, correct?
No, I said I had it.
That's it. So you never, so what you
You guys have to talk over each other again. Mr. Ross, please rephrase the question again, sorry. Let's do this over again.
The only rules you had growing up, when this is growing up, is that you had a bedtime, what was the other one? Mr. Clark, I asked whether or not when Miss Smith was growing up, you did have rules in your household for Miss Smith.
Yes.
And what were those rules?
You can't do it.
You kind of love it. And
Mr.
for her to do it,
I know, we've got to stop doing this.
it's certainly not.
I understand, he takes a, I think you're fast and I think he's slow, so maybe, Mr. Rod, just take like a breath just to see if he's done answering his question, because I think he takes a pause, and you're ready to go, and that's when he starts talking, so. All right.
Mr. Clark, go ahead, again. So your rules growing up in the house were what? When Miss Smith was growing up in your household, she was younger, what were your rules? That Miss Smith would never be fired or in the year.
I'll respect what you're in, I'll respect everyone.
Okay, and you never tried to discipline her when she was growing up?
No,
Okay, never.
never.
Okay, so then she wouldn't have really been disrespectful to you because they weren't trying to discipline her in any way. She just wasn't following the particular rule.
Just you can't.
Okay, so now Miss Smith moves back now to you now, she's 36 years old. Comes back from Florida, moves in with your wife. She's living under your house again, correct?
All right.
It was your house,
Yes.
so your rules.
Yes.
So Ms. Smith did, again, decide to not abide by your rules because she was going into the refrigerator to get butter for her mom. That made you upset, correct? Because go ahead.
Well, I just want to know
When you saw Ms. Smith going into the refrigerator on May 3rd, 2020, that made you upset, correct?
Yes.
And that's because that's one of your rules in your house, correct?
The rule is to keep the program.
To keep the her
Yes, sir.
and then you approached her, when you saw her going into the fridge.
Yes, sir.
She didn't come after you, right? You went to her at the refrigerator door, right?
Yes, sir.
And then you did one again, or that?
No.
You didn't get that?
After she said, if you open the child, whatever, and she slammed the door.
So you grabbed the door from her.
I did not touch the door. She slammed the door.
Well, did you say you wanted this?
She did.
I thought you said that you wanted this.
Oh, no. She shut the door.
Okay.
The door. And it was and then she slammed it.
Okay.
And then she came back and push her. And she said, oh,
So Mr. Clark, but you just said that you wanted that promotion to stand. That Ms. Smith wasn't the one moving towards the ticket. Ms. Smith said that you were sir, Ms. Smith, correct? You were the one that went towards Ms. Smith. Ms. Smith is just reaching into the refrigerator. Isn't that right? I'm sorry?
That's the reason why you're pretty good.
Just to leave your picture.
Yes, sir.
But you went towards her. At that point, you never saw her come towards you, right?
She never told you what.
Okay, no further questions, Your Honor. Thank you.
All right. Mr. Day?
Mrs. Dwyer, let me just clarify, okay? No.
Mr. Day, I think it would be helpful if you stood a little closer to Mr. Clark. I just feel like with you guys being at the podium, he doesn't quite hear the questions.
So, Mrs. Dwyer, when you walked into the house that day, you walked into the kitchen, do you remember that?
Yes, sir.
Did you see her at the refrigerator?
Yes, sir.
And you walked towards her?
Yes, sir.
Was that because she wasn't supposed to do that? You understand what I'm asking? You walked towards her, she was at the refrigerator, is that correct?
Yes, sir.
Why did you walk over there?
Because I'm my favorite room.
When you got to the refrigerator, you walked close to her, did you?
When I said my favorite.
Hold on, did you walk close to her?
Yes, sir.
All right, and then what did she do?
She moved the door like that. Then she slammed.
What did she say?
I was on that.
And then, hold on, when you do that, what did she say first? Break it down step by step. What did she say after she went that door? Hold on, no, I'm not going to just back up, right? Take your time, if I'm not too fast, you let me know. Just slow down. We don't want to follow you, we don't want to get you. So you have to walk to the refrigerator, right? She slammed the door, what happens then? What happens next?
She told me why.
Okay, hold on, so she, that one, outside the door, she comes towards you. All right, so one you walk towards her, the refrigerator. And another one, she came towards you.
Yes.
When she came towards you, was she angry?
Extremely angry.
Was she cussing?
Yes, sir.
All right, and then what did you do? You describe it when you did it wrong.
I pushed her over.
All right, is that when you pushed on her neck?
Yes, sir.
What's the objection? He's already said it, but stay.
So, I want to ask you questions about this cussing, because the prosecutors are shocked to have that cuss. Sir, are you a religious man?
Yes, sir.
And how often do you go to church?
Every Saturday.
And what kind of denomination are you?
Saturday.
And have you served for your entire life over 60 years, contributing 10% of your income to church?
62 years, sir.
And are you a very religious man? Not religious. He spent a lot of time on this.
I think the door was open, so I'll allow a little of it. I'm gonna allow a little bit of it.
So, do you consider yourself, sir, a very religious man? And have you ever been to a hospital? For that reason, nothing further.
Overruled on the objection for the record. Mr. Rabb, any more questions of this individual? All right, sir, you can step down.
Be careful right there, just put on the floor, okay? Mr. Clark, you can bring that out to the man. Go ahead and have a seat. Yes, we can have a seat. Yes, sir.
Defense, call your next witness, please. All right. Ladies and gentlemen of the jury, both the state and the defense have now rested their case. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has spoken. Thank you. Thank you. Mr. Rabb, are you ready to provide your closing argument? All right, please proceed. Thank you. Yes, sir, you may. Why don't you shut it up? I'll just tell you if you can just pop it up there. All right. Could you move it back just a little bit? Or maybe move the podium back a little just because, or I could easily move it like, why don't I do that? You keep it wherever you want and I'll just sit here. How's that? Okay, thank you.
So at the beginning of the day, we talked about what the city burden was, what the city had approved. We heard that the city had approved only two things. That Mr. Clark touched, struck, and smith against the road. For the only two elements that the city ever had approved today, for the only two elements that only agreed that the city only had approved it and required. Now, did that happen in the city of Bergen? Let's ask unquestionably. Her testimony committed in the city's extent. And Smith stated that while she was cooking breakfast for her mother and Mary for early afternoon, late morning of May 3rd, 2020, that Ms. Smith reached into a stainless steel refrigerator to get butter for her mother. The simple sight of that enraged the defendant enough that he approached Ms. Smith and said, "Don't move my fridge." Started cussing at her. Ms. Smith then, standing between the refrigerator door and the refrigerator, it's her body slammed in the refrigerator. She gets punched in the side of the neck. You heard Ms. Smith testify that she had to stop her young child from going towards the defendant. And the only action Ms. Smith ever took was to tell her son to go get her phone so she could call 911. You heard testimony from Ms. Smith's sister, in this case, the defendant's biological daughter, that she heard the same exact thing. That she saw someone on the system that she heard her father yelling at Ms. Smith. And you heard testimony from former Hedgemore, who stated that he saw those same indications on this incident. And that the statements made by the defendant at the time of the actual incident, not months later, were completely inconsistent throughout his time just on scene. Now, we don't insert the only two elements that the state has to prove today for you to be able to find the defendant guilty. Now, we talk about ways that you could weigh the credibility of witnesses. And this is exactly what the judge is going to read you at the end of the closing argument. There are no other ways to weigh credibility. The witnesses have an opportunity to see the things that I heard. Yes, they did. It's clearly there. Mrs. Clark was in the house, she heard what was going on. She said her father was the one going, and I said, no, not speaking in a soft voice. No. Did the witness have an accurate record? You tell me. Mrs. Whitson, you have an accurate record for you? Yes, she did. She answered my questions correctly. She answered Mrs. Grace's questions correctly. Wasn't trying to ever evade a question. Did the defendant answer any questions directly? Did his memory of the incident seem to be accurate to you when he was speaking? Because guess what? According to this jury instruction, the defendant is examined during the witness testimony the same way any other witnesses testify. Now, there should be something on this board that young that can be everything wake up and steps. And that's whether or not an evidence has had in this case. You tell me, ladies and gentlemen, the jury. Who's the only person that has happened in this case? It's the person on trial. Mrs. Smith is on trial. Mrs. Clark is on trial. Corporal Commissioner wasn't on trial. The only person on trial in this case is Mr. Clark. And that has to do with the credibility and weighing the credibility of his testimony. We talk about family members testifying against each other. We talk about how difficult to process things. A stepdad, before most of their life, Mr. Clark said 5-6 years old would be her stepfather. That was her father for you all her life. She did the same thing testified against Mr. Clark. Miss Clark, again, biological daughter, took the same thing, testified against Mr. Clark. That has to really be doing the decision when you go back and deliver this matter amongst yourselves. Now again, the only two things you need to consider is whether or not you've been touched or struck Mrs. Smith against her will. Whether or not she was instructed about what was matter, this wasn't a discipline. Maybe it was that attempt at discipline of an adult, not a child. Someone whose stepdaughter comes home years later, after a meeting, who now has to live by his rules again in his house. And that's what the minister said. That's why he was the aggressor in this case. He walked up to Miss Smith, standing out of the prayer. It wasn't Miss Smith who was the aggressor at all. When you go back and deliver it amongst yourselves, keep all this in mind. What the state have proved, and how you wait for him to be looking for today. Thank you.
Mr. Day.
My client was an aggressor and enraged. First of all, what do you consider my client and enraged?
Yes, sir.
I didn't hear that from anybody. That's just something prosecutors that make up on their own. I understand that we live in different times now, and that the children around the world and the parents don't anymore. I get that. I get that we're in a world that kids can do or say whatever they want to do. That's game. But I don't care if it's 25, 15, or 55. When you go home and basically tell your parents that they're in charge, and that they can do what they want to, and they're not going to follow the rules set, I still believe parents have a right to speak up. Especially when those kids coming back in the last 35 years of age, with 2 children in tow, 1 on the way, and haven't worked. And the whole time she's there and being happy with her, all of a sudden she goes to school. That's asking a lot of your parents. Especially your 85-year-old stepmom. Now, there's a lot of things about this case that cause me concern. The biggest was, I kept looking at the evidence. None of this was historical. I looked at it over and I tried to replay on my story that was told by Ms. Smith. And I tried to think in terms of the 85-year-old man with a rolling his fist and punching her, as she said, hey. And I didn't think about it as anything to say, oh, maybe this is how it was. And by the way, I asked, if you have any interest in those questions for specific reasons, I asked you, but he has some experience in it beyond me. But when someone balls up their fist and they punch, the size of their fist, wherever it makes impact, 1 to the somebody, presumably, you guys should like to test them out anymore, but that doesn't really matter. The point of it is, that's what you believe. And he said, oh, yes. And then I asked him, but if you were to strike someone with a longer object, let's say a longer piece of wood, it would be different. And he said, yes. And the reason I asked those questions, when I came with these photographs, in particular, the state to the two, it showed bruising underneath the chin, underneath the 5 centimeter chin. I asked her, you see that there? Yes. And I showed you, so you have to check out that one. And there was bruising way down from that, it was the bottom of the neck and that here. First of all, there was 2 red spots, under the chin, and on the neck. From much further away, the size of your fist. First. But second, more importantly, was state exhibit 3. It showed a red mark in the lower part of the neck. And then it showed a red mark again underneath the chin part, and between those two is white skin. No red mark. Now think of this for a minute, a solid fist makes striking with an object and it needs a mark. There's not going to be a blank spot there in the middle. But if someone were to stick their forearm there and push you back against this part of your body, the forearm is much larger, and you very well leave a red mark underneath the chin, on the bottom of the neck, as you're pushing away. Well, first of all, but this is evidence. Not only can I fix their score with being punched, which is very difficult when you see a 35-year-old man do not understand.
Grounds? No, grounds. What's the objection? Overruled.
You can use your common sense. You can use the ability, age, infirmity, and size of people to apply to the back of the head. Difficult to imagine 75 years and doing that. But the evidence is actually supports what 80 was. The evidence is actually supports what he said with the forearm, not with this. Now, when I talk a little about this, is for this, because one of the things that I believe that Ron is going to tell you is that you can find reasonable doubt in criminal cases 2 ways. The first is a conflict in the evidence, and the second is a lack of evidence. I'm going to give you an example of the conflict in the evidence. She said that she punched solidly. She said she pointed out where to stand, to the lower part of her neck. Remember, I said out loud to you, let the record reflect that she pointed to the lower part of her neck. And the witness said, yes. The reason I asked that is on the photograph, showed the red mark underneath the chin. So her testimony from that point is completely inconsistent with the photograph. So that's an example of how physical evidence can be conflicted with testimonial evidence. It's more consistent with what the photograph is. Secondly, her testimony itself. First of all, she didn't see examination that she leaves home at 15 because that's time was his first step. Pretty young age to leave home. She leaves home. Simply because completely with her stepfather. Wasn't that part of the rules. Comes back 37 years of age. She knows 2 kids and a baby on the way. And remember, she started kind of talking about the word. I thought there was a reading in the refrigerator. She delivering. I decided to take that refrigerator. Here's the 37-year-old baby on her way home, unemployed, 2 kids, her parents to support her. And the first thing she tells her stepfather is to come take a nap. That defiance, and look at the defiance we saw on the stand. Imagine that at home. What my father got. It wasn't any discussion whether she decided that was what makes one big. Then I asked her in particular, are there occasions where you get angry with him? You argue with him? Yes. I said, does it happen all the time? Yes. You should see it. She should see she's glad. You should see her checking with us. But she said she was angry. On this day, I asked the particular question. This isn't someone innocent inside the refrigerator. You know what the rules were. What do you think? This is ridiculous. Doesn't matter. The point is, she knew the rules. She completely defies them. And then when he challenges her, I asked her, you were angry, weren't you? And her answer was, yes. And you yelled at him, yes. Yes. Remember your sister came to that spot? Not your sister doesn't really have anything to say, other than she sort of because what she has, here this is in. But the one thing I thought was kind of interesting, this is where the kind of dynamic comes in. You know what's going on. But one thing the sister said is, the sister said that she heard her father with a loud voice. If we never say that she heard her sister yelling. What her sister said, she yelled. That's interesting. She heard that. She did. My sister is right to pay. I don't know if that's one but I think that's something that they intend for you. She didn't. The sister has nothing to say other than she's alive. The one guy she said that she's angry, she's very troubled, and then my client comes over, her and just punches her. Now, obviously, the drug test is a different story with that. He approaches her, says you're not supposed to be in the refrigerator. She can slam the door multiple times. I can do what I want to do. Kind of like when I moved in the house, I'm taking in that refrigerator. Kind of like that. I can do what I want to do. And then she came towards Mr. Now, what crime is going to give you during the case is self-defense protection. Because self-defense applies in this scenario. A lot of people think about self-defense as, you shoot someone because they're attacking you or something like that. Self-defense includes any act where you touch, strike, push someone when they are doing something that calls you concern. Here, they're going to get specific instruction on that. All right. So there actually is several before they can go in there and how that happens. And what I think I'm going to tell you is that my is justified in using non-deadly force. Non-deadly force just means not using force and killing not push back. It's non-deadly. My point is that I use non-deadly force, considering circumstances which surround the use of force at the time. The circumstances surrounding the use of force at the time, and one, that environment where she's not on the rules of the file. She's angry, she's yelling at my car, and then my mind is not effective with her. Why is it making my head? Because she's coming towards him. That is where the issue of what is going on between those two and what Mr. Clark knows about her is right. Mr. Clark knows that she's been violent and he's been violent. He knows that she's been violent in other instances where the approaches she lived in. He has specific knowledge of that. And because of that, he has comprehension and fear. Now, add to that the fact that he's 85, very small in stature, he's much larger in stature, and much younger, so, for all of those things, he certainly had reason that she came towards him, angry and yelling, to be concerned. He doesn't have to be concerned she's going to shoot you. He can be concerned she's going to push you, or strike you. That's all right. You have a right to defend yourself. Self-defense, even if someone's not pushing you. All he did is separate himself, pushing her backwards. That's what he did. And under the law, she was knowing what her attitude was, knowing where her attitude of aggression, knowing where her attitude she's been before, that's what he did. He has a right to do that as well. And Ron can give you some instructions about that in more detail. Credibility is always an issue. Her credibility, you know for sure that she can commit twice a crime of dishonesty. One of which she would be. The second she did not repeat. It was only when she was confronted about that today by the prosecutor that all of a sudden she remembers, oh yeah, there was another kind of dishonesty that I committed. When you go back to the jury, one of the things you have to consider is credibility witnesses. I mean, it's Mrs. Smith and Mrs. Clark. That's who's there. Exactly how this thing takes place between two of them, what they see, who's saying, So you have to provide that you have some specific instances of crimes of dishonesty. She perpetuates dishonesty, but not even discloses the price here until she's confronted with a lawyer. Oh, yeah, what's the value today? Hopefully, so when you judge credibility, these are the kinds of things that you consider. What about the written statement? She finds today that my baptized brother or the young son, I think that's completely illicit sympathy to you. And the reason I tell you that is because she got out a written statement. She didn't say anything. She was asked by the police officer, right? She didn't say anything. Give the details of what happened. Make sure you include everything. And she didn't say anything about her kid or anything. That's only now that they tried. So that's another example of a conflict between what she wrote and what she testified to on the stand. I also asked her specifically these instances where you and my client get in conflict with each other. It happens a lot because they get all the time. So this isn't something new. This is something that's been going on. And she can see that. But she also can see that she gets angry at it. And yells at it all the time back. Well, I know, got it. I'm forgiving. Kids on the show. I understand. Okay? But is it unreasonable that an 85-year-old man may not think like that? Right? It may be believe some sense of respect is important. And yelling and cussing and being disrespectful is something that he doesn't want her to do. But we know it happened, she heard it, and we know that they put it over all the time. So those are the kind of things that we're not solved today. But I think it makes a good point. It makes a point. The family dynamic is such that this is wanted to do there, she wanted to do. She believed she wanted to run the show. She believed she coming back because her mother and someone her stepfather, she would decide to do this thing. And she did from day one set the rules by saying, I'm not taking that refrigerator. That sets the tone right there. And then you add the fact that my client has not been seen physically violent and aggressive, you know, she's had those instances where they're close, and all those things combined, all that happening. So I asked when you go back into the jury, first of all, I know they get talking to clients. They get talking to clients. I would simply ask you, when they're speaking with you, does the evidence agree with what they're arguing? Because we can get up and say, my client coached her rage. No one says that. You said that. That's not evidence. It's what the witnesses say they stand behind. I hope when you go back into the jury and think about the case, talk about the case, not only is there a conflict in the evidence, the testimony from this man does not match physical evidence, the photographs of the injuries, the way she said it happened, that would not have happened. And second, her statements, she added to her written statement, something she never said before. Her instances of arrest for crimes, you know, crime involving science, and therefore we can disclose those, which is talking today, all the way. We do not convict you of crimes based on that kind of credibility. Those kinds of witnesses. That's exactly what the rule contemplates. Conflict in evidence, lack of evidence, and credibility is suspect at best. That is reasonable data. And I ask that you go back and in the jury room, talk about the evidence, and come back to it. Thank you. Now, Coach,
Yes, sir. Yes, sir. All right, Mr. Ryan. Yes, sir.
First thing I'd like to touch on is that according to the facts, the reason why this is such a bad person is because when keeping the act of Porter County a little criminal. Ms. Smith was unemployed, had 2 kids, and according to this today, a baby and a Jackie had twins that she was pregnant with. Then now look at her as well. That doesn't make someone less credible. That makes someone fairly weird. Not working, or your stepdaughter not working, is in self-defense. Your stepdaughter having 2 children and being pregnant is in self-defense. Mr. Dave's right about one thing, parents are allowed to drive. Wrong about another thing. They're not allowed to hit their adult children for no reason, because they're going for a refrigerator. That is not self-defense. I didn't know that it was in rage. He came on the stand and I was crossing him. I didn't even have. And why was he mad? Because someone like this opened a refrigerator. That's testimony you heard here today. He was angry. All of you know that. There's no question about that. There's no about that. But let's touch on that. We talked about that this morning. We agreed that the standard was not beyond all doubt. It was reasonable doubt. So where did those remarks on that come from? Based on the evidence that you have here today. Where did the remarks on that come from? You tell me. The evidence presented to you today shows that those remarks given the defendant, based on testimony, based on physical evidence that they saw, testimony from the victim, testimony from CCSO deputy, testimony from the defendant. Now, you are not allowed to defend yourself because you're concerned. That's not going to be the jury instruction of that drug evidence here. A challenge to find that in the jury instructions. Now, Mr. Day wants to say that there was an inconsistency in testimony because of this one statement, he stated that he didn't have somewhere on. What does that have to do with whether or not he owns the crime? Does that really need to be questioned for the witness that is relevant? The testimony that you heard today? It doesn't. The standard of the statement for today was not reasonable doubt, not beyond all doubt. With the testimony, the evidence that was presented to you today, the only conclusion that you can find if you go back and break officer's cells is that Mr. Clark was being arrested in this case. Mr. Davis said that Mr. Clark was being arrested because he's an 81-year-old man. He was so afraid of his head. Why did he approach his head? If it was really reasonable, Mr. Clark would believe that his head was such a threat, why would he do that? The Lord told you that when you were really Solomon Smith, he was standing 15 feet away. If he was afraid, he had such a reputation of violence. But he didn't do that. There's no reasonableness for self-defense. None. Based on the testimony, based on the facts, based on the evidence of the crime, based on the ways that we, as everyday people, weigh the credibility of anyone telling us what they saw, what they heard, they learned. That's what you have to consider when you do that out there. And as you find it, I'm going to go with me and indicted against this.
All right, thank you, everyone. At this time, the court is going to take a brief recess. We're going to go back to the room so we can discuss some matters out of your presence. Trust me, it should not take long. And then we'll bring you all back in, and I'll give you final instructions so that you can retire to deliberate, okay? Thank you, everybody. All right. Everyone, please be seated. I have something that I need to bring up with you guys because I've been noticing it all day. And I don't know exactly how to address it because usually I don't know if everybody else is seeing it but me. I'm watching Mr. Hallman over there crashing. Has anybody been noticing that but me? I mean, he is literally suffering. He's been sitting there like this, just going like this. And every once in a while, he just goes like this. As I said to you at the beginning, I was worried that Mr. Hallman works in the ER. He may be tired. That's why he wanted out of it. So and he's our African-American juror. I'm very aware of the fact that we have a black juror today. But I'm sitting here as a judge watching him crash, and I don't know how to address it. Because I don't know if we should make inquiry to him if he's okay and if he's okay to proceed. And just check in with him and make sure he's not just a little bit tired and he's going to be okay to get through the rest of this. But I wanted to bring it to your attention, because particularly during your closing argument, I was sitting over here and I just kept, I mean, he was looking to me like he was going down. And that's something. What do we do? I mean, first time it's happened to me where, I mean, we've had situations where we had a juror literally fall completely asleep during trial, and in that instant, you know, we all have to agree, the juror's asleep, they're not paying attention. So, you know, we have to let them go, but I'm just wondering if we should make some type of inquiry. It's I don't want to embarrass the gentleman, but I'm just wondering how to address it with him and make sure that he's okay to get through what I think will be, you know, not a real long time, but just to say, hey, you're all right, can we get you some coffee? Are you okay to proceed or something like that? Thoughts, guys? Is anybody, first of all, does anybody else see that with me?
I don't quite see it.
Okay.
And the reason I say that is I was very observant in the jury selection. I agree he doesn't want to be here. I see that more than anything else.
Okay.
He's very frustrated.
Sure, and people don't want to be here.
I don't know who that is, okay? But
A lot of people don't want to be here. I was just worried that I thought he might be starting to go like tired, like I'm going down and just.
I've been able to get the different judge, and I see somebody being discussed for whatever reason, but I haven't seen him close his eyes with me.
Well, I just saw that, that's why I asked. Okay. That's what I was seeing over the last maybe 10 minutes, so I just wanted to check in with you guys and say, should I just, you know, just keep going, don't bring it up at all, you know, maybe he'll come back, maybe he goes back to the back, he has a little coffee, he comes back in, he's fine, because we're at the end. Okay. All right, I mean, because we're at the end of the trial, and maybe it's a little different at the beginning of the day, but I just, for everyone's benefit, I thought I might want to tell you guys what I'm seeing, ask for your feedback. And that's your feedback, and we'll go with it. We'll just, everybody hope that everything will be okay. All right, so you guys, have you guys talked about the instructions? Are we in agreement on this?
Earlier today, Your Honor, because of what happened at the lunch break with part of the case tomorrow.
Yes.
Otherwise, all the other instructions are identical to what they were on Tuesday.
Okay.
Mr. Day has no objection to that.
Yeah, no issue. Stay.
We just need to print them again.
Is that standard instruction?
Yes.
This is standard.
You have anything?
Oh, we can print the ones from yesterday.
Your Honor, I will just run through this. The state would
Okay.
the standard instruction. Not that I-
Sounds good.
But
All right. So here's what I'm going to do. I'm going to go upstairs for about 5 minutes because my judicial assistant leaves at 4. Mr. Rabb, based on what we're doing tomorrow, I think what I'm going to do, since we're doing our motion in the morning and I called in the jury at noon, is I'm going to ask for another courtroom to put the jury in because we're going to be in here. So logistically, I got to figure out how that's going to work. So I'm going to go organize that right now and I'll be right back. Okay? Yes. What's that? I could. I've already reconsidered a few things. I didn't think I'd reconsider, so. But that's, thank you for suggesting. All right, I'll see you guys in a minute.
The same instructions?
I just changed the case was defended.
So you want to know them to me?
Yes.
Okay.
You don't have it, oh, you just want it earlier in there?
Yeah.
Okay.
Should go after the battery. You have your. Okay, perfect.
Here,
Usually it goes after the front door.
huh? Huh. This is the summer catalog. You wanna?
So which period? Bill Wilkie swear, not in the I believe. She used to swear to go back and bring that picture out. I said, I'll never bring that anymore. He was scary, I think. Did you see his mom?
Your issues over there?
Tissues. Oh, let me check.
Go on.
Tissues? I'm sorry. What is tissues? Outside? Oh.
Look at that.
They're looking good.
Look
at that.
I wonder if that's where you're going to go over.
He looks at me and he's like, don't look at that asshole. Yeah. Yes, it's great.
You know what, I think that's more than. You shot.
I know, that's all the work is.
Well, when we go by, I couldn't even read the reason why we look at it.
People like, really? Years ago. And then that was it. And then he
Look at the bright side, you got parts of this courthouse clean, never been clean in 20 years. That's the positive side too. I mean, I see that up here. They have discussed it in there. They didn't have it clean. Right. You see where they're at. No, it's moving for them today. Really, you know, man, you almost smell the difference. Yeah. They did. Last line there, come back and get hold of them every time.
Work and then resolve. We're at. We're all like,
Ron, we're back in session.
Yes, be seated.
Oh, thank you. Is this all the ones you printed, plus the solvent stuff? Oh. Oh, okay, perfect. Thank you.
You can hold on to them, man.
What's that?
You can hold on to the tissue. You can hold on to it. Oh, okay. All right.
Whose tissues are those?
Joe,
The courthouse.
Really? I didn't know the courthouse had tissues. Since when? I think you brought those yourself.
No?
Oh? I'm gonna have to go requisition some of those.
he does go above and beyond, going everywhere.
He does. Should I ask why 3G is in all bold?
It should be not big.
It is, that's okay.
Judge, you want me to find the prosecutor?
No, he's fine.
It's fine.
He's fine.
It's fine.
As long
As long as it's not in all caps. Mr. Day, did you already look through these? Okay. And Mr. Rab has too?
Perfect.
Fantastic. So all we have to do is get that self-defense and we're good. Okay. Mr. Clark, are you doing okay? You need to take a break for any reason, sir?
He's good, Judge.
Okay, good. I know it's a long day, and I try to make sure I check in with everybody to try to make sure people, they need a break, they take one. Especially you, Joe.
Yes. I was trying to think of a way that, you know, if we finished early and I was able to have a ruling, that we would, you know, be able to give people sufficient time in the end that there was something important. So that's what we're doing. How are we doing, Todd?
Good, Judge.
Good? All right.
problem is that here. They should be clear off.
Are we ready, everybody? Okay.
Sure, I see you walk back in, I'm sorry.
I was just sitting here kind of going through some stuff.
Yeah,
I did tell Judge Foster,
because before I was, getting ready for my trial week, I started trying to watch a little bit of his trial, just to kind of see, as another judge, how he was handling things, and I did tell him that the sound is terrible on YouTube, except when he's speaking. You can't hear the witnesses, you can't hear the lawyers, there's some delays, I don't know what they're gonna do to try to fix it, but I've already had people today tell me I tried to watch it, it's not watchable, so I'm required to do it, but I don't know if it's going to be an effective way of allowing the public to have access to courts, at least at this point, they have access to watching it, but I'm not so sure what they're hearing of it, but it's what we got for now, so that's, I guess, what we're doing. Well, I actually got, it was funny, there was an email yesterday that said, Judge, you need to turn on YouTube because someone's watching. I'm like, really? Who's watching? Is it my mother? Did she call and say I want to watch my daughter? I don't think my mom is watching, to tell you the truth, but maybe she will one day, I don't know. So how are we doing with that, the self-defense argument? Do you have it? Oh, you did give it to me, okay. I didn't know I had everything. All right, so I've got, all right, so let's go through these. I got 3.1, introduction to final instructions, 3.2, statement of the charge, 8.3, battery, 3.6, justifiable use of non-deadly force, 3.7, plea of not guilty, reasonable doubt, burden of proof, 3.9, weighing evidence, 3.10, rules for deliberation, 3.11, cautionary instruction, 3.12, verdict, the verdict form, and then submitting the case to the jury.
Mr. Honor, and just for the record, on Tuesday, weighing the evidence doesn't include the state's incorrect.
Oh, okay. So, yeah, okay, a little bit different than the one and the other. Yep. Okay, great. So we can bring them back? Yeah, let's bring them. Okay.
You're on the jury.
Thank you, everybody. Please be seated. Ladies and gentlemen of the jury, again, I thank you for your time here today. I have some final instructions to give you before you deliberate, and it's quite lengthy, and I apologize that I do have to read it all in its entirety. The good news is that all of these instructions will go back in the jury room with you. So if I'm going on and on and on, and you start to think, oh, I didn't quite hear something, you're going to have every one of these instructions. You can read through them carefully if you would like, okay? All right. Members of the jury, I thank you for your attention during this trial. Please pay attention to these instructions I am about to give to you. Edwin Clark, the defendant in this case, has been accused of the crime of battery. To prove the crime of battery, the state must prove the following elements beyond a reasonable doubt. Edwin Clark actually and intentionally touched or struck Danya Smith against her will. And intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. It is a defense to the crime of battery if the actions of Edwin Clark constituted the justifiable use of non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or modest harm, and as such does not include mere bruises. Edwin Clark was justified in using non-deadly force against Danya Smith and had no duty to retreat if he reasonably believed that such conduct was necessary to defend himself against Danya Smith's imminent use of lawful force against himself. In deciding whether Edwin Clark was justified in use of non-deadly force, You must consider the circumstances by which he was surrounded at the time the force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Although, as I have previously explained, the defendant had no duty to retreat. Based upon appearances, Edward Clark must have actually believed that the danger was real. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Edwin Clark and Dinah Smith. If in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Edwin Clark was justified in the use of non-deadly force, you should find him not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Edwin Clark was not justified in the use of non-deadly force, then you should find him guilty. If all of the elements of the charge have been proved. The defendant has entered a plea of not guilty. This means you must presume or believe that the defendant is innocent. The presumption stays with the defendant as to each material allegation and information through each stage of trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant's charge was committed and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one that is not stable, one that wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some point, at some other time, make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. The defendant in this case has become a witness. You should apply the same rules to the consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony that witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the testimony or of the evidence or the testimony of any witness. There are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is my job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything that I may have said or done that made you think that I preferred one verdict over another. You may find the defendant guilty as charged or not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. And you will receive this sheet, and it says, State of Florida versus Edwin Clark, case number 20MM656, verdict. We, the jury, find as follows as to the defendant in this case. Check one only. First, the defendant is guilty of battery, or second, the defendant is not guilty. So say we all. Dated and signed by our foreperson. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you agree on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached the verdict, you must not talk about this case in person or through telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. These rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. The instructions say kindly leave these devices on your seats where they will be guarded by the bailiff while you deliberate. However, I do know the bailiff will actually take them from you when you leave. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of this case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, please send a note through the bailiff, signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For two centuries, we have lived by the Constitution and the law, and no juror has the right to violate the laws, the rules that we all share. And that's everything. So thank you. At this time, jury is released to deliberate. Okay, thank you. All right, everyone, can be seated.
All right, so, Mr. Rob? Yes? Yes, sir. I was gonna say, that's fine. Just, let me know how to contact you. I'm gonna go back to my office and I'll come back whenever you get a hold of us, all right?
See you guys in a little bit.
A little bit. What's that? Yeah, okay, all right. Just leave all this stuff here for now. See if I can get. Oh, sure. Anytime you want to do that, we can certainly do that. But it's been a long week, hasn't it? It's not over either.
Well, I can tell you this, you're the only prosecutor so far that's done two trials in a trial week since we started back from COVID, so. See, you can just put down all those like little notes to your fellow colleagues and be like, Lawrence first, Lawrence first, Lawrence first. Maybe just take a great big, like a piece of paper, put it on your door, big Sharpie. I mean, there's gotta be some bragging rights when you do 2 trials in a week. I just gotta say.
Yeah, a bunch of moral support.
It's still good experience. If you were to ask me how many trials I lost in my career, I couldn't tell you. And I'm in my field, so. All right, I think I said. Is there someone there?
I need to go over this. I need to get it done. Walmart. Quiet. Peace.
No, I wonder, I just didn't, when they didn't tell you that we were, when the light kept going out, we were at bad weather.
Yeah, it looked bright. I had found 8 months for stuff 4 days in a row. I can read it again.
And tomorrow, what you,
That's good. Good, see? So I was saying the other day, this husband and wife, recommend, quick first started. It's all natural, how they use, hands. They're following, apparently, and kind of crazy thing. They want to put together.
Well, that whole thing started, if you were not buying everything, you were buying, putting it anywhere.
No.
Probably that's the first time in my life when I was concerned about people buying something on the shelf.
It was next. Sure. Perfect line with a basic cities and food building on similar physics. Food chicken and stuff, airline and stuff, government and stuff, food shares with the community, and it's just two buildings. And with that, something like that. Really buy. Just go ahead and show you how.
Well, I'm buying much better.
Those two events that kind of illustrate how we. incident.
You have it wrong. One time you think it's that you short of sleep, look back and you're last for hours, and the next night you think that day forever, the fact. You're making it like that. Well, that's yeah, I'm sitting there, area where you can't see, but I can do whatever I want. Yeah. All right. What happened is we all went on to social distancing. We didn't want to use it for regular experience. We're using an appointment. So we now So you have one at one door and one at the other door, and anybody, any interaction. So you have that way.
Richie's shooting with all that.
We're all that one area. There and saying, well, we just have to go. Yes, because we're thinking that we can all do things. Got a lot of questions. Yeah. All right. Yeah. All right. Question all the delivery and I will require the building is the delivery. Yeah. Yeah. All right. Well, tonight's early, actually. Usually the other one is 9:55. Wow. So you, tonight I get home probably, probably by 24 minutes. I play my 10 game. I usually get home right away. Sometimes we go, I don't go all the time, but sometimes we go out after school. So my, I don't go every week, sometimes I go every 2 weeks, every other week. And I usually stay in both there. Around 4.5 hours. Friday, but Friday.
Yeah, for sleep, very. Yeah.
It's hard to do.
That's the difference.
Some guys say they want to work. Some guys have to work all the way up.
When I got going, I don't know. I'm also 2 hours.
It's not bad anymore. You are not a man.
Yeah.
It's almost like we should come back and today. Yeah. That's quite a regular thing on the public scale.
Then it's enough to play on the regular scale. Or then,
Is that on the public scale?
no, it's I Tuesday, I went to skating on the internet. And then my regular team is all on the posting on the record, and then Sunday.
Whatever that first started, the Chrome career.
Yeah.
It
It can't do it. I mean, it's still not good. I mean, Wednesday, it's so young, and then Friday, it's still so, I think it's just people work.
Yeah.
And Saturday, is usually the biggest time. So that. Now, we make it right. Yeah, we're going to get the those skills.
I saw the practice to get back. Going away to any kind of minor league or kind of farm league or because they're stuff like that. So right, just give it a whole I had extraordinary facilities. Okay.
Yeah, right. We'll just see what those means. Sorry. Yeah, take your time, I have to go to like. We're good. Sounds good. All right. We need to try.
Yeah, you know, I'm sure it will.
Thank you. Arise for the executive session.
Thank you, everyone. You can have a seat. We're, someone not called Mr. Brown.
He's on his way.
Okay, perfect. Get all this out.
Right.
Thank you, everyone. You may be seated. Ladies and gentlemen of the jury, I understand you have reached a verdict. And with the foreperson, please hand the verdict form to Joe, my clerk. Thank you. Thank you. And could you please publish the verdict? Thank you.
In the County Court of the Pennsylvania Municipal District of Kane and with the Public County Florida Criminal Act. State Court Conscience Eric Court. Case number 2021-6 declines. Verdict. We review following as follows. As to the defendant in this case, the defendant is not guilty. So single dated March 4, 2021. Signed by person one.
Thank you. Would either the counsel for the state or the defense requested the court pull the jury? Okay, thank you. So ladies and gentlemen, jury, at this time, I have one more thing that I need to read to you. This one's short. This one's short. Okay. I wish to thank you for your time and consideration on the jury today. I wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussion, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request may come from those who are curious or from those who might seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror. And so at this time, you are all released with our thanks. We have prepared some certificates for you to thank you for your service today. Did I give those to you, Jeff? I did. And I just want to ask you guys before you leave, is there anything that you liked or disliked about this process? We just are brand new. I think you heard one of our attorneys say this is our fifth trial since we had COVID shutdown a year ago. My first was 2 days ago. So is there anything we could do better, make you guys more comfortable, or make this process a little better for you guys? No? I appreciate that. Oh, it's hard for you to walk? Okay. Okay. Well, I'll tell you, the way it used to be, before we have these COVID restrictions, now because of the social distancing and all these requirements, usually what would happen is you guys would come in here, you'd sit in the jury, and literally you would go right to a jury room and sit there. And it's just got a small conference table and, 6 chairs. And then as we got our directives, which found from the Supreme Court of Florida and from our chief judge at Fort Myers, that we could start doing jury trials again, then the directive was, in order to have the jurors sit and talk together, we have to find a good courtroom for them to go into. So it used to be this right next door. I don't know why it isn't anymore, but I'm going to bring that up to say, going from 2A to 2B is a long walk. So I don't know the reason behind that, but I will take that. I appreciate that because it is. I was even asking Joe, I said, what's taking so long at one point? I just kept you guys there right there because I knew something was short. So having to have to walk that whole way. So we'll have to do that better. I really am hoping that this isn't a thing that's going to go long term, that we're going to start slowly opening up again and be able to do more things to bring more jurors in. But this is just what we have until we can move into our next phase. So. But thank you for bringing that up. And we tried to get you guys some snacks and some waters and stuff, and so you had at least some comfort things in there and coffee. So we're getting there, but I appreciate it. And I certainly appreciate you guys being willing to serve. My biggest worry as a judge was that we were going to start jury trials again, and we were going to have people who just didn't want to come in the courthouse and were scared and worried that we wouldn't do it well. It's hard to get people to serve on jurors anyway. It's time to worry if we don't have the voting restrictions. So. Truly, I appreciate your service even more right now with coming into the courthouse with everything else that's going on in this world. So thank you. Do you guys have any questions for me or any comments you want to make? No? Thank you again. I appreciate you being here and have a wonderful day. Thank you. All right, everybody can be seated. All right, so Mr. Clark, because the jury found you not guilty, that means you are free to go at this time. I just want to provide you with one little comment that I think you already know. There's no way you can live with that stepdaughter of yours. I know that you probably have, your wife is still there. I'm sure the family dynamic is so hard for you. But I sat here the whole time and I thought, I don't think you guys could ever live together again. It's just, there's too much conflict. Me too.
On the street with friends, the church is taking him. No, there's no solution to this. She doesn't know where to go supposedly, and this is a bad situation. And I don't know how to solve it. I wish I could somehow intervene here because
Yeah.
the man doesn't know where to go to the street. He doesn't know how to get there.
No.
He doesn't know where to go. This.
Yeah.
I mean, maybe some way to reconcile.
I don't know. I just know, I'll tell you, sir, that before I took this job as a criminal court judge, I was a family law attorney for 25 years. And I saw so much family conflict, not just in divorces, but that's what I did mostly. But then the kids, the little kids, the adult kids, the relatives, the whole family just started to all polarize. And in your situation, I think that there's going to be some difficulties, that if they're, I don't know if counseling, family counseling, I know you're a religious man, maybe the church, but I worry, I'm telling you today that you're free to go, and I'm scared a little bit that if you go back into that situation, I could see you here, or somebody in your family here again, and I just thought I'd give you some words of wisdom, as much as words of wisdom, to hope for your sake and your family's sake, that you don't end up back here, because family issues can't be resolved in court, really. So I wish you the best of luck. That would be great. That would really be great, because I feel like there's been a lot of pain in your family, and that pain has existed since the very beginning. So I don't know what you start to do to heal that, sir. But thank you to everyone again, to the attorneys. I appreciate your preparation, your professionalism, and the way that you handle yourself during this trial. It's definitely a pleasure to work with all of you here. So you're all free to go. Court will stand in recess.
All right, so we're in recess.
We'll see you tomorrow. Thank you. We have hearings at 9 o'clock, yep.